Good day, everyone. I'm Mrs. Andrea Hilo Suerte, and together with me is my co-discussant, Mrs. Lucille Joy L. Paniergo, both teaching at Oton Central Elementary School, Schools District of Oton. We will be presenting to you our topic about Republic Act Number 9485, also known as the Anti-Red Tape Act. So here are the objectives. Number one, define RA 9485. Next, understand what Anti-Red Tape Act is. Know the rights and benefits under RA 9485. And improve the delivery of public service in the country under Republic Act 9485. So here are the guide questions. Number one, what is anti-red tape law? Number two, what is the concept of RA 9485? Number three, what are the rights and benefits under Republic Act 9485? And what are the efficient government services? So what are the concepts of RA number 9485? So Republic Act number 9485, otherwise known as the Anti-Red Tape Act of 2007, was enacted into law to improve efficiency in the delivery of government services to the public by reducing bureaucratic red tape, preventing graft and corruption. It is hereby declared the policy of the state to promote integrity, accountability, proper management of public affairs and public property, as well as to establish effective practices aimed at the prevention of graft and corruption in government. In June 2007, the Filipino government tried to tackle this problem through the Anti-Red Tape Act, or ARTA. The act included simplifying measures to reduce red tape in service transactions, and it established a formal corruption prevention tool for service provision. So why do they call it red tape? It is generally believed that the term originated with the Spanish administration of Charles V, King of Spain and Holy Roman Emperor in the early 16th century, who started to use red tape in an effort to modernize the administration that was running his vast empire. So we have here the different rules of Republic Act 9485. So rule number one, the coverage. So we have here section number one. So this rule shall apply to all government offices and agencies, including local government units and government-owned or controlled corporations with or without original charter that provide frontline service as defined in the Act. Those for performing judicial, quasi-judicial, and legislative functions are excluded from the coverage of the Act. However, their responsive or respective frontline services are deemed included. Rule number two, the interpretation. Section number one. This rule shall be interpreted in the light of the declaration of policy found in Section 2 of the Act. It is hereby declared the policy of the state to promote integrity, accountability, proper management of public affairs and public property, as well as to establish effective practices aimed at the prevention of graft and corruption in government. Towards this end, the state shall maintain honesty and responsibility among its public officials and employees, and shall take appropriate measures to promote transparency in each office or agency with regard to the manner, of transacting with public, which shall encompass a program for the adoption of simplified procedures that will reduce red tape and expedite transactions in government. So, section number 2. For purposes of these rules, the following term shall mean: action. This refers to the written approval or disapproval made by a government office or agency on the application or request submitted by a client for processing. Citizens Charter refers to an official document or service standard or pledge that communicates in simple terms information on the services provided by the government to its citizens. This describes the step-by-step procedure for availing a particular service and the guaranteed performance level that they may expect for that service. Citizen. With reference to the Citizens Charter, this refers to the clients whose interests and values are addressed by the Citizens Charter. Therefore, includes not only the citizens of the Republic of the Philippines, but also the stakeholders, including but not limited to users, beneficiaries, other government offices and agencies, and the transacting public. Complex transactions. This refers to requests or applications submitted by clients of a government office which necessitate the use of discretion and the resolution of complicated issues by an officer or employee of said government office. Such transactions to be determined by the office concerned. Fixer. Fixer refers to any individual, whether or not officially involved in the operation of a government office or agency, who has access to people working therein, and whether or not in collusion with them, facilitates speedy completion of transactions for pecuniary gain or any other advantage or consideration. Fixing. This refers to the act that involves undue facilitation or transactions for pecuniary gain or any other advantage or consideration. Frontline service. This refers to the process or transactions between clients and government offices or agencies involving application for any privilege, right, permit, reward, license, concessions, or for any modification, renewal, or extension of the enumerated applications and/or requests which are acted upon in the ordinary course of business of the office or agency concerned. Irrelevant requirements. This refers to any document or performance of an act not directly material to the resolution of the issues raised in the request or needed in the application submitted by the client. Next is the officer or employee. This refers to a person employed in the government, office, or agency required to perform specific duties and responsibilities related to the application or request submitted by a client for processing. Published materials. This refers to printed, computer-generated, or photocopied materials, and procedural manuals or flowcharts may be available to the public or uploaded in the official government websites, containing the basic information on assessing frontline service. Report card survey. This refers to an evaluation tool that provides a quantitative measure of actual public service user perceptions on the quality, efficiency, and adequacy of different frontline services, as well as a critical evaluation to the office or agency and its personnel. Simple transactions. This refers to requests or applications which only require ministerial action on the part of the public officer or employee, or that which present only inconsequential issues for resolution by an officer or employee of said government office. Rule number 3. The re-engineering of systems and procedures. Section number 1. Within 1 year from effectivity of the rules, each office or agency shall A. Determine which processes or transactions constitute frontline service. B. Undertake re-engineering of transaction systems and procedures, including time and motion studies, if necessary, and after compliance thereof. Letter C. Set up their respective service standards to be known as the Citizens' Charter. Section 2. The re-engineering process shall include a review for the purposes of streamlining of the following. So number 1 or letter A, steps in providing the service. B, forms used. C, requirements. D, processing time. And E, fees and charges. Section 3. In the evaluation of official forms, government offices and agencies rendering frontline services shall limit the number of signatories to a maximum of 5 signatures of officers or employees directly supervising the evaluation, approval or disapproval of the request, application, or transactions. The head of government office or agency shall prescribe through an appropriate office order the rules on the proper authority to sign in the absence of the regular signatory as follows. So number 1, if there is only one official next in rank, he or she shall automatically be the signatory. Number 2, if there are 2 or more officials next in rank, the appropriate office order shall prescribe the order of priority among the officials next in rank within the same organizational unit. Or, number 3, if there is no official next in rank present and available, the head of the department, office, or agency shall designate an officer in charge from among those next lower in rank in the same organizational unit. Next, the rule number 4, the Citizens' Charter. Section number 1, the Citizens' Charter shall include the following information. A. The vision and mission of the government office or agency. B. Identification of the frontline services offered and the clientele. C. The step-by-step procedure to obtain a particular service. D. The officer or employee responsible for each step. E. The maximum time to conclude the process. F. Documents to be presented by the client with a clear indication of the relevancy of said document. G. The amount of fees are necessary, if necessary. The procedure for filing complaints in relation to requests and applications, including the names and contact details of the officials, channels to approach for redress. I. Allowable period of extension or for extension due to unusual circumstances. Example, the foreseen events beyond the control of concerned government office or agency. J, the feedback mechanisms, contact numbers to call and or persons to approach for recommendations, inquiries, suggestions, as well as complaints. Section 2. The Citizens' Charter shall be in the form of information. Billboards which should be posted at the main entrance of offices or at the most conspicuous place and in the form of published materials written either in English, Filipino, or in the local dialect. The head of office or agency shall constitute the task force to prepare a citizens' charter pursuant to the provisions of the Act and these rules, taking into consideration the stakeholders, users, and beneficiaries of the frontline services, and shall conduct consultative formulation and refinement of the provisions of the charter. The participation of non-government organizations and other concerned groups shall be encouraged. The head of office or agencies shall formally issue and release the charter and shall monitor the periodically review its implementation for section number 3. For section number 4, the office or agency shall review the Citizens' Charter whenever necessary, but not less than once every 2 years. For section number 5, the assistance of the Civil Service Commission and the Development Academy of the Philippines may be requested for purposes of complying rules number 3 and number 4. For section number 6, the activities in rules 3 and 4 shall be monitored by the Civil Service Commission through its regional offices and field offices for re-evaluation and benchmarking. Rule number 5, the accountability of heads and offices and agencies. The head of the office or agency shall be primarily responsible for the implementation of these rules and shall be held accountable to the public in rendering fast, efficient, convenient, and reliable service. All transactions and processes are deemed to have been made with the permission or clearance from the highest authority having jurisdiction over the government office or agency concerned.
Hi, good morning everyone. Good morning sir and classmates. I'm Mrs. Lucille Joy Paniergo from Auton Group. I will discuss the continuation of RA 9485, also known as the Anti-Red Tape Act. From Rule 6 to 10. Rule 6. Assessing Frontline Services. Section 1. All offices and agencies are enjoined to undertake on a continuing basis programs to promote customer satisfaction and improve service delivery and other similar activities for officers and employees in frontline services. Section 2. Acceptance and denial of the applications and requests. 1. All officers or employees shall accept written applications, requests, and/or documents being submitted by clients of the office or agency. 2. The responsible officer or employee shall acknowledge receipt of such application and/or request by writing or printing clearly thereon his/her name, the unit where she/he is connected with, and the time and date of receipt. Number 3. The receiving officer or employee shall perform a preliminary assessment of the request so as to promote a more expeditious action on request. and shall determine through a cursory evaluation the sufficiency of submitted requirements for a request or application, taking into consideration the determined response time for the transaction. 4. All applications and requests in frontline services shall be acted upon within the period prescribed under the Citizens Charter, which in no case shall be longer than 5 working days in the case of simple transaction and 10 working days in the case of complex transactions from the time the request or application was received. 5. Depending on the nature of the frontline services requested or the mandate of the office or agency under unusual circumstances, the maximum time prescribed above may be extended. For the extension due to the nature of the frontline services, the period of the delivery of frontline services shall be indicated in the Citizens Charter, which shall not be more than 5 working days for simple transactions and not more than 10 working days for complex transactions. 6. No application or request shall be returned to the client without appropriate action. In case an application or request is disapproved, the officer or employee who rendered the decision shall send a formal notice to the client within 5 working days from the receipt of the request and application, stating therein the reason for the disapproval, including a list of specific requirements which the client failed to submit. Section 3. Working Schedule. Heads of offices and agencies which render frontline services shall adopt appropriate working schedules to ensure that all clients who are within their premises prior to the end of official working hours are attended to and served even during lunch break and after regular working hours. Offices and agencies may consider providing frontline services as early as 7 in the morning until as late as 7 in the evening to adequately attend to the clients. The frontline services must at all times be complemented with adequate staff by adapting mechanisms such as rotation system among office personnel, sliding flexi-time, reliever system, and especially in peak times of transaction or providing skeletal personnel during lunch and snack time. Section 4. Identification Card. All officers or employees transacting with the public shall be provided with an official identification card, which should be worn during office hours. The information on the identification card should be easy to read, such that the officials and employees concerned can be identified by the clients. For certain agencies, where an identification card is not provided, the officers and employees must wear nameplates or other means of identification. Section 5. Public Assistance Desk. Each office or agency shall establish a public assistance complaints desk in all their offices, where an officer or public knowledgeable on frontline services shall at all times be available for consultation and advice. The desk shall be attended to even during break time. The office or agency shall institute hotline numbers, short message service, information communication technology, or other mechanisms by which the clients may be adequately express their complaints, comments, or suggestions. It may also institute one-stop shops or walk-in service counters. Special lanes may be established for pregnant women, senior citizens, and persons with disabilities. Section 6. Automatic extension of licenses, permits, and authorities. If a government office or agency fails to act on an application and/or request for renewal of a license, permit, or authority subject for renewal within the prescribed period, said permit, license, or authority shall automatically be extended until a decision or resolution is rendered on the application for renewal. In this instance, The applicant shall be informed prior to the expiration of the original period that more time is required to evaluate the application or request. No automatic extension or renewal shall apply to an expired permit, license, or authority. Rule 7. Report Card Survey. Section 1. The Civil Service Commission, in coordination with the Development Academy of the Philippines, shall conduct a survey to obtain feedback on existence and effectiveness of as well as compliance with the Citizens Charter and how the office or agency is performing insofar as frontline services are concerned. The survey shall also be used to obtain information and/or estimates of hidden costs incurred by clients to access frontline services, which may include, but is not limited to, bribes and payment to fixers. The evaluation tool may be linked with the program of the Civil Service Commission to 1. Provide critical evaluation of the office or agency and its personnel. 2. Check client satisfaction, operational efficiency in the areas vulnerable to corruption. 3. Highlight best practices. 4. Provide incentives for excellent service delivery and give recommendations for improvement in proven areas and inefficiencies in frontline services. The Civil Service Commission shall publicize the results in an annual report card survey and furnish the government agency concerned the result of the survey assessment, evaluation, and/or observations. Rule 8. Disciplinary action. Section 1. After compliance with the substantive and procedural due process, the following shall constitute violations of the Act and its rules, together with corresponding penalties. Light offense. 1. Refusal to act application and/or request within the prescribed period or any document being submitted by a client. 2. Failure to act on an application and/or request or failure to refer back to the client a request which cannot be acted upon due to lack of requirements within the prescribed period. 3. Failure to attend to clients who are within the premises of the office or agency concerned prior to the end of official working hours and during lunch break. 4. Failure to render frontline services within the prescribed period on an application or request without due cause. 5th, failure to give the client a written notice on the disapproval of an application or request. And 6th, imposition of additional irrelevant requirements other than those listed on the first notice under Rule 6, Section 1. The term prescribed period shall refer to the period specified under the Citizens Charter. Penalties for light offenses shall be as follows. First offense, 30 days suspension without pay and mandatory attendance in values orientation program. The Civil Service Commission and the Office of the Ombudsman shall promulgate a values orientation program which shall include anti-red tape and anti-fixing workshops suitable for this purpose. Second offense, 3-month suspension without pay. Third offense, dismissal and perpetual disqualification from public service. Grave offense, fixing and collision with fixers in consideration of economic and other gain or advantage. Now, what are the penalties? Of course, dismissal and perpetual disqualification from public service. Okay, Section 2. The finding of administrative liability under the Act and its rules shall not be a bar to filing or criminal, civil, or other related charges under existing laws arising from the same act or omission as herein enumerated. Section 3. Criminal liability for fixers. Fixers shall suffer the penalty of imprisonment not exceeding 6 years or a fine of not less than 20,000 pesos, but not more than 200,000 pesos, or both the fine and imprisonment at the discretion of the court. Section 4. Administrative jurisdiction and procedure. The Civil Service Commission and the Office of the Ombudsman shall have administrative jurisdiction over non-presidential appointees, while the Office of the Ombudsman and the Presidential Anti-Graft Commission shall have administrative jurisdiction over presidential appointees. Their respective procedures, as determined by appropriate laws, rules, and issuances, shall be observed regarding any violation of the provisions of these rules. Rule 9. Immunity. Section 1. Any public official or employee or any person having been charged with another under the Act and who voluntarily gives information pertaining to an investigation or who willingly testifies therefore shall be exempt from prosecution in the case where his information and testimony are given. Section 2. The discharge of correspondent or accused to be witness may be granted and directed by the investigating body or court upon the application or petition of any of the respondent or accused informant and before the termination of the investigation, provided that 1. There is absolute necessity for the testimony of the respondent or accused informant whose discharge is requested. 2. There is no other direct evidence available for the proper prosecution of the offense committed except the testimony of the said respondent or accused informant. 3. The testimony of said respondent or accused informant can be substantially corroborated in its material points. 4. The respondent or accused informant has not been previously convicted of a crime involving moral turpitude. Lastly, said respondent or accused informant does not appear to be the most guilty. Evidence adduced in support of the discharge shall automatically form part of the records of the investigation. Should the investigating body or court deny the motion or request for discharge as a witness, his/her sworn statement shall be inadmissible as evidence. Section 3. If the respondent informant granted immunity fails or refuses to testify or to continue to testify or testifies falsely or evasively or violates any condition accompanying such immunity without just cause as determined by the office or agency concerned, his/her immunity shall be cancelled and he shall be prosecuted criminally and or administratively. Rule 10. Final provisions. Section 1. The activities embodied in these rules shall be charged to the office or agency's regular budget. Section 2. An oversight committee composed of the Civil Service Commission as head and the Office of the Ombudsman, the Presidential Anti-Graft Commission, and the Development Academy of the Philippines as members shall ensure the immediate, swift, and effective implementation of the Act and its rules. Section 3. These rules may be amended or modified as necessary. Section 4. If any provision of these rules shall be declared invalid or unconstitutional, such declaration shall not affect the validity of the remaining provisions. Section 5. These rules shall take effect 15 days following its publication in a newspaper of general circulation. That's all my report. Thank you, and God bless everyone.